So let me start with a couple of things, Ms. Hall, and make sure you understand. So first of all, I'm not the judge that's assigned to your case. I want to make sure you understand that. I believe your matter is assigned to Judge Edwards, but I am the presiding judge this week, which means I handle things that are super time sensitive to try and get them handled quickly in advance of before your the assigned judge may or may not be able to get to it. And Judge Williams indicated that this matter that it did need to be handled on an expedited basis because of the way it was filed, and that it was okay for the presiding judge to go forward. So I am going to be the one making the decision on your motion for temporary restraining order to stop the foreclosure that I believe is scheduled for next week. But whatever happens today going forward, Judge Edwards would still be the judge that you would be dealing with in your case, okay?
Yes, Your Honor.
Okay. So Ms. Hall, I have had a chance to review your motion for temporary restraining order to stop the foreclosure, but we are having a hearing, and so I wanted to give you an opportunity to sort of talk me through and make a brief presentation about why you think the court should grant temporary restraining order and stop the foreclosure that is supposed to be held next week.
Yes, Your Honor. My name is Narayanda Mitchell Hall. I am seeking both an emergency temporary restraining order and a preliminary injunction to stop the wrongful foreclosure on Lot 2 at 5090 Alexander Avenue, a property that is not legally encumbered by the security deed ServBank is attempting to foreclose on. The central issue before the court is the legal description in my security deed is not the description of Lot 2. It is Lot 10 shortened easement description that was added into my deed. The Ironstone retracement plat survey and the Ironstone notes, the affidavit affecting title, and the recorded subdivision plat all show that the description is in my deed is not Lot 2.
Okay. Can I ask you a couple of questions, Ms. Hall? First, but at the very beginning of the hearing this morning, I told you that I would want you to give me some information in detail about the extent to which you had attempted to reach ServBank so that someone could be here on behalf of ServBank. Can you tell me just a little bit about what efforts you took?
I processed ServBank registered agent yesterday morning at 9:45. I uploaded to the ServBank portal all of the documents on May 26th at 7:02. I also emailed loss mitigation and got a return receipt of them receiving my email on May 26th at 7:30.
And was that
on May
the matter that you uploaded? Was that regarding the lawsuit? Hang on, sorry. Was that regarding the lawsuit itself, or was that regarding specifically this hearing, that there was a hearing today?
It was the lawsuit and the summons.
Okay. So not this hearing. The summons generally.
And the hearing. The hearing.
Okay. Okay, go ahead.
And I also uploaded it on e-file so that it could go to Mr. Mitchell.
Okay. Okay. Your motion has sort of, you have alleged, you've said all the things that you're supposed to say in a petition. But there's some legal standards about when and the extent to which the court can or should grant the type of relief that you're seeking. And one of those issues is whether or not there is an adequate remedy at law that you would be able to pursue. And oftentimes in these foreclosure cases, the issue is that you could pursue, if in fact your house is foreclosed upon, and that is wrongful, you can pursue a claim for damages for wrongful foreclosure. And if you have an adequate legal remedy, which would be a lawsuit for wrongful foreclosure, it typically means that you don't also get equitable relief, right? Which is the TRO, the injunction that you're asking for. Can you address that issue for me, ma'am?
The relief that I'm seeking, Your Honor, is you can't, with the equity in the house, if I lose my home, I don't have anywhere to be. And I need this to go before the court so that ultimately for curative actions.
Well, so I can't give you legal advice, but I guess my point is you have this lawsuit. Even if let's say I don't give you injunctive relief, I don't say that the foreclosure is stayed and the foreclosure goes forward. The arguments that you're making would also be in support of a suit against the foreclosing entity saying you wrongly foreclosed my house, give me damages. Why is that, to your mind, why is that not an adequate remedy for you?
Because your home is something you can't get back. Losing it is not a good thing, especially when it's not even my home that's in that description. It's irreparable harm.
Okay.
And money cannot get you your home back.
No, I understand there is law that says that, primary residences can be unique and sometimes can be the subject of equitable relief. But I am concerned about the likelihood of success on the merits here as well. I think you probably have an adequate remedy at law, and I'm concerned that because you could sue for wrongful foreclosure. But I also am concerned that on the merits itself, I'm not exactly sure I'm understanding your legal argument about how it is that you came to believe that the legal description in your mortgage and in your deeds, on which the lien holder is foreclosing, were inaccurate.
If you, Your Honor, I put up the exhibits. There is a corrective deed in Ironstone's report,
Mm-hmm.
and it's totally different than the description that's in the power of sale and my security deed. My security deed shows that I'm the front of lot 9. Lot 9 is in the back. The In 2017, Your Honor, I did discover, by once Ironstone came out, did the retracement plaque, discovered that nothing in my deed matched anything on the ground. In their report, they said that my description cannot be located on the ground. None of my paperwork from my closing, anything references lot 2, not the description, not the dimensions of this lot. Everything is based off a description that cannot be found.
I understand that you are alleging that the deed is not accurate, but ultimately, I think I understand there was a corrective deed. But at the end of the day, you, as I understand it, did in fact take out a mortgage with ServBank or its predecessor and have not paid on that contract. Is your position that that contract is completely invalid and that you are under no obligation to pay because the description is inaccurate?
My take on it, Your Honor, you all do not have a lien on this property because the description is not this home. It's not a payment issue. I would like for them to correct the legal description, because in a foreclosure, all of that has to be accurate. The legal description of the home has to be accurate. The lien has to attach to the home. Their remedy could be sue me personally, but your lien does not attach to the home.
Okay. Anything else that you want to add, Ms. Hall?
Just respectfully, this hearing is regarding the incorrect legal description of the property. The description is of lot 10 inserted into my deed. That is somebody else's property.
Okay. Thank you, Ms. Hall. I appreciate the time and effort that you have put into preparing these pleadings, and into being patient this morning while I got to some other matters, and then in walking me through your position. I sympathize with the position that you're in. I understand how frustrating it is. But at the end of the day, the court is, equitable relief is extraordinary relief that should not be granted, in, absent extraordinary circumstances. And ultimately, one of the things that the court has to concern itself with is, in addition to the factors that have been asserted correctly in your motion under 91165, one of the things that the courts also consider is whether there is an adequate remedy at law. And if there is an adequate remedy at law, the court should not grant equitable relief. And my understanding is that a party, if you are in fact foreclosed upon, you can sue the foreclosing entity for wrongful foreclosure. And while I understand your position, absolutely, that would still involve you losing your house, I don't believe that satisfies the legal requirements for the granting, that gets rid of this issue of you having an adequate remedy at law. Also, based on what I understand about the law, I also have concerns about whether you have a substantial likelihood of success on the merits, because ultimately, based on what I'm hearing so far, it appears that the company has the factual and legal basis to proceed with a non-judicial foreclosure, which is what they're doing currently. Now, ultimately, I may be proven wrong, but based on what I know currently, I don't
Excuse
believe.
me,
Hang on, I let you talk, so let me finish.
yes, ma'am.
If you have something else to say, I'm happy to let you address the court, okay?
Yes, ma'am.
So all I was saying is that essentially my assessment is I believe that you do have an adequate remedy at law in the form of a suit for wrongful foreclosure, if in fact the foreclosure goes forward. And number two, if the court were to reach the issue of whether to grant equitable relief, in assessing the factors, I do believe that I have some concerns about whether you have demonstrated a likelihood of success on the merits of your underlying claim in terms of the validity of the documents that underlie the claim that ServBank has. And so for those reasons, I would deny the request for TRO that you have filed today. Ms. Hall, did you want to say something or did you have questions?
Yes, ma'am. In 2017, ma'am, before I purchased, everybody knew that the legal description was wrong to my property. I just became aware of all of this. It was in front of the court trying to get for reformation that the description of this property was wrong. They dismissed the case against the prior owner and sold it the same way to me.
I understand.
I did not.
Ms. Hall, I understand. And let me be clear, I'm not making an assessment of the validity of your claims. What I'm telling you is that ex parte, with little information, I do not believe that there is a basis for equitable relief here today, especially extraordinary equitable relief in the form of ordering that a foreclosure not go forward, number one, because I believe that you have an adequate remedy at law And I believe I have concerns about whether or not you have demonstrated a likelihood of success on the merits of your underlying claim. Now, again, I know it sounds like I'm commenting on the validity of your claims, and I am not. I am making an incomplete decision with the best decision I can with incomplete information. But that is my assessment, and you are free to go forward and take whatever legal action you believe you need to take going forward in this case. What I am telling you is that today it is my job to assess the request that you have made, which is for an emergency injunction. And I don't believe that you have satisfied the legal requirements for that. And so I'm going to deny that request. So what will happen next, Ms. Hall, is I'm going to enter an order that denies your request for a TRO. And then the case will go back to Judge Edwards, and you can seek relief from Judge Edwards in whatever manner you wish to seek in the case going forward. Do you understand, Ms. Hall?
Yes, ma'am.
Okay. Thank you very much. I will get an order on file, and then you can proceed with Judge Edwards, and I will wish you good luck with your claim.